Good afternoon, everybody. Can you all hear me?
Yes, sir, we can.
We can hear you, sir.
Yeah, good afternoon and welcome to the training for today. I hope we're all comfortable. You're seeing me well. See me clearly, yeah?
Yes, sir.
Yes, sir.
Yeah, good afternoon, everybody. My name is Sojiye Lilly-Tariah. I'm the vice chair of the Rivers chapter of the Institute of Chartered Secretaries and Administrators. And we'll straight away go to the business of the day. Welcome to the training titled Organizing and Managing Annual General Meetings, the Compliance Conundrum. I'll take the protocol. Welcome the President and Chairman of Council, Mrs. Fumi Ekundayo, FCIS, and all bearers of office, the Registrar, CEO, Mr. Babatunde Okuneye, ACIS, the Chairman, River State Chapter, Sir Sebastian ACN, ACIS, members of the EXCO, River State Chapter, distinguished ladies and gentlemen. My name is Sojiye Lilly-Tariah. I'm your host for the day. I'm a legal practitioner practicing out of Port Harcourt. I'm a governance professional too. I'm an associate. Your speaker for today is Mr. Blessing Eyidengha, ACIS. We're going to be very time conscious as we carry on. First of all, immediately after the introductions, the chairman of the chapter will give his opening remarks, and the presenter will present his paper, and thereafter we'll go into question and answers. Then there'll be the vote of thanks and closings. I wish us all a wonderful and very interesting time. May I now welcome the chairman to give his opening remarks. Chairman, sir.
Hello. Good afternoon, everybody, and welcome. Thank you, Moderator, for your warm welcome. On behalf of the President and Chairman of Council, Mrs. Fumi Ekundayo, FCMS, and Registrar of our dear Institute, I would like to welcome each and every one of you for finding time to join us in this webinar training. Just like you've been informed in the publications, it's a capacity enhancement training to provide support for practicing and student members of the Institute and the general public in the area of the management of annual general meetings. You would agree with me that it's a very topical area. A lot of practitioners struggle with it. You know, it is one of the very important compliance requirements as provided by the laws that regulate the operations of companies in Nigeria. So the River State chapter, we thought that it was important that we bring this specialist area to our members and to equip you adequately to be able to address whatever challenges you may be having at your workplace. Before we did this, we had engaged a lot of our members, and indeed, we could say that we have had to put up this training in response to the yearnings and cries of our members that they needed something much more practical to be able to succeed in the workplace. So the chapter, I've put this together for you, both for experienced practitioners, mid-level practitioners, and for students of the chapter. Those who are also attempting to take their exams, their qualifying exams, it will be of immense benefit to all of them. Our speaker is very, very renowned, is rich with a lot of experience in the governance of companies, boards, and AGMs for that matter. As you will hear shortly, when his profile will be read by the moderator, you will find out that he's very much equipped to do justice to this topic. And it is our hope that at the end of this session, we will go home with the necessary tools for you to succeed. Very importantly, you take down your questions. You can drop your questions in the chat box, chat room. I'm sure the moderator will take it up from there. Then during the formal question and answer sessions, we will try as much as possible to respond to all your questions. A lot of members have reached out to us that they require a certificate to demonstrate that they've undertaken this training from Icsan. We have obliged that. And as we've communicated to you, kindly send a message to Grace with the name, the way you want it to appear on the certificate, and we will ensure that your certificate is sent to you at the end of the training. So, on behalf of the River State Executive, members, and Council, I would like to warmly welcome you to this webinar. Do enjoy it, and hopefully, we will bring you similar rich trainings to ensure that you are capable and able to deliver on your governance role wherever you find yourself. Thank you so much. Mr. Moderator, over to you.
Thank you, Mr. Chairman. Can you all see clearly on your screen? Can you see? I'm sharing my screen. Can you see clearly?
Yes, sir.
Yes. The profile of Mr. Blessing Eyidengha is a legal practitioner, a graduate of the River State University of Science and Technology, now River State University, was called to bar in 2003, inducted as an associate of the Institute in 2021. His practice experience include private practice with the law firm of Uchesi, Eyidengha & Co. in 2003, till about 2006. He joined the law firm of Austerity Legal Union and Partners, a renowned law firm in Port Harcourt. In 2008, he left the law firm and went in-house for a career in banking by joining Transatlantic Mortgages Limited, where he rose to become the head legal and risk management, and later as company secretary. He was there till 2013. In 2013, he joined All-in Invest West Africa Limited, a company with head office within the oil and gas free zone on Rivers State, as legal manager, corporate services. His services were later transferred from All-in Invest West Africa Limited to the Intels Group, where he continued as legal manager, corporate services. He was later elevated to the office of senior legal manager, corporate services in 2017, and held that office until 2023, where he provided support for over 20 boards under the Intel Group. He's currently the managing solicitor of Fortis Flex Solicitors, a Port Harcourt-based law firm, and continues to render corporate secretarial services to Intels Nigeria Limited in that area as external solicitors. He's a member of a number of companies within the All-ins Group, from where he provides corporate services oversight to over 20 corporate entities in the group. He has held service positions as part of the board of the Rivers State chapter of the institute and currently serves as the publicity chair. He's a member of Rotary International and currently club secretary of the Rotary Club of Port Harcourt. His hobbies include reading extensively, and he's a lover of combat sports. He's happily married and blessed with 4 children. So that's a brief profile of our guest speaker today, Mr. Eyidengha. I'll now invite Mr. Eyidengha to present his paper. I would urge us to pay attention, as indeed the topic is going to reveal so much. Briefly, quite a lot of legal practitioners and other corporate service providers struggle with this topic. Its application, the law surrounding it, and the trends around it. I'm sure this will be a very rare opportunity for us to have it almost free of charge. I wish us all a very enriching time.
Thank you. Thank you, sir.
You're welcome.
Greetings, everybody. Mr. Chairman, amiable moderator, my dear colleague. First of all, and our guests who have signed in, first of all, I would like to thank you for the opportunity, Mr. Chairman, and the Rivers chapter of the ESCO, for this unique opportunity to speak to our colleagues. I fully associate with the dire need to provide some level of hands-on training in the area of management of board meetings or AGM meetings, as it were. I want to commend, first of all, the chapter, who in the past 1 year has dedicated time, resources, and effort in ensuring that the gap existing between colleagues who have practical skills and those who are chartered and are yet to have a placement in any corporate environment to exercise their skills is bridged. I know because within the period I was Hello? Hello, can you hear me?
I can hear you. I can hear you.
I can hear you now, sir.
Gentlemen,
I
I
can
must
hear you.
sincerely apologize. I had clicked the unmute button, but I only realized that I was still the only one muted in the house. So you permit me to start all over again. Mr. Moderator, I plead that you allocate some more time to me so that I can do justice to my subject matter. Well, ladies and gentlemen, I would like to, first of all, thank the leadership of the River State chapter of our institute, the Institute of Charter Secretaries and Administrators, for affording me the opportunity to speak with our colleagues on this topic. It's a very interesting, very pulsating topic for many because it speaks to one aspect of our practice as chartered secretaries. My gratitude essentially goes to the commitment, dedication, and forthrightness of the Institute, particularly the Rivers chapter, that has dedicated so much time, resources, and effort, at least to my knowledge, in the past 1 year, in ensuring that there is an abridgment of the knowledge gap between colleagues who are already engaged as practicing chartered secretaries in companies and other organizations, and those of our younger colleagues who do hold the charter of the Institute have not found a placement in any of the companies to work in. So I recall we had the mentorship program at the level of the state chapter, and that mentorship program saw the transition of knowledge from one arm of the membership to the other. And it is very frustrating to me that the kind of feedbacks we get suggests that it was very impactful. So, Mr. Chairman and your team will say thank you for that. So, our topic today is organizing and managing annual general meetings, the compliance conundrum. Before I delve into the merits of our topic, I would like to state that I had the good fortune of that I had no more than 1 hour to deliver on my subject. Based on that time schedule, you permit me, ladies and gentlemen, to be very parsimonious with my time, so that I may not dwell on so much details because I assure you I had planned to cover several grounds. I will have to quickly go through my topic while at the same time ensuring that you get the deliverables that are promised. So I will, okay, let me see now. Let me see if I can. Mr. Chairman, permit me to share my, yes. Let me see if I can. Where's my stop? Let me, come on, help me. Yes, please. Fantastic. So, awesome. So, magnifique. All right, so on this topic, I have created this outline that I had hoped will guide our conversation. The topic essentially is broken down into 4 major parts. We have the part 1, which will be dedicated to understanding what the general meeting is. And then part 2 will focus on organizing the general meeting. You see that there are so many items we have to cover under that. Then there's part 3, managing the conduct of the annual general meeting itself. Part 4, which is our final chapter, dedicated to the challenges or the conundrum, of compliance, identifying it and providing a solution to it. And on that, we will wrap up on this topic. So, but before we address the merits of our topic, I think it is important that can everybody see my screen here, please?
Yes.
Yes, yes, we can.
Yes, we can. Yes.
All right.
Yes, I can.
Okay, just a minute.
Yes, I can see the screen.
Okay, fantastic. So before we go into the merits of our conversation, I think it is important we try to impose some level of order on audio. Just a minute. Permit me. Just a minute. I'm having a bit of an issue here. Okay. All right. Okay. So before we go into the merits of our conversation, I would like us to impose some level of order on the terms that are used in the topic. Prominent among them are the words organizing, managing, and the conundrum. I think it is important we understand what they mean in relation to our topic because on a very loose note, organizing and managing almost seem to be the same thing, but we need to assign some meaning to it so that we can drive home our conversation on our topic. So organizing, from what I have here before me, organizing is the present participle of the verb to organize, and to organize simply means to put together in a particular order. And the term is said to be synonymous with to arrange, to categorize, to codify, to catalog, to group, to classify, to tabulate. I mean, the list is literally endless, you know. So in relation to our topic, the term shall be understood to mean arranging or putting together the entire processes necessary to ensure a successful annual general meeting of the company. In the same breath, the term managing also has its root word as the word manage. You know, it is also a present participle of the verb to manage, and it means, you know, taking charge or overseeing something. It could be a business, an organization, or a process. And it is said to be synonymous with to administer, to conduct, to control, to guide, to maintain or oversee, to govern or to supervise, and it goes on. So for our own context, to manage the annual general meeting would mean giving oversight or overseeing or supervising the conduct of the annual general meeting as an event in and of itself. The last of the words we have to consider here is the word conundrum. In fact, for those of us who are lawyers, the word conundrum is usually thrown around in courts because everybody wants to speak to the conundrum of the law, okay? So conundrum simply means the confusing or difficult problem or question. So used in the context of our topic, the conundrum would have to mean the difficulty or challenge of conforming or complying with laid down rules and regulations governing the organization and conduct of the annual general meeting. So this now brings us to the part one of our topic, which is what really is the annual general meeting. A lot of definitions have been given as to the meaning of annual general meetings. All of them are right in and of themselves. But the key material to look out to is that it is a congregation of the members of the company. It's an annual meeting or a congregation between the board of directors of the company, shareholders of the company, senior or executive management of the company, and other stakeholders. By law, it is required to be held annually or each year. And at that meeting, the meeting affords the company the opportunity to have the shareholders listen to the directors, give a report of the affairs of the company for the financial year under review. At the same time, to also give proper account of the stewardship of the affairs of the company, the opportunity to ask questions of the directors, to know so much about the business and operations of the company, all in an effort towards ensuring that their stake in the company is well protected. So The meeting essentially is intended to talk about the development and growth, and stakeholders that are there all come to see if there will be some level of goal congruency where the interest of the company, of the board members, of the shareholders, top management, and even stakeholders who are invited to the meeting, are all satisfied. Now, fundamentally, the meeting also affords the shareholders the opportunity to not only discuss, ask questions, but to pass resolutions or votes that would affect the management of the company into the foreseeable future. So key decisions are taken at the annual general meeting that affects the future outlook of the company. Now, from a legal standpoint, the authority in Nigeria for the conduct of annual general meetings by company is section 237, subsection 1. That particular section requires every company in Nigeria, except the companies that are specifically accepted, to hold annual general meetings. Now, the timing for the annual general meeting is that for companies that have just been incorporated, they are required to hold annual general meetings within the first 18 months of incorporation. Existing companies, however, have a maximum of 15 months to hold their annual general meeting, subject to the power of the CAC on application made specifically for that purpose to enlarge the time by a further 3 months in the event of default. Now, the annual general meeting by law, when called, must be so described as the annual general meeting of the company. And like I initially said, every company in Nigeria must hold annual general meetings except the 2 companies that are accepted. Now, it may be interesting to note this. Under Nigerian law, as you will remember, there are 3 types of companies. Section 21 of CAMA says companies limited by shares, companies limited by guarantees, are unlimited companies. Now, of these types of companies, subsection 2 makes it very clear that these companies could either be public or private. So of these 3 types, you have 6 categories. Private company limited by shares, public company limited by shares, private company limited by guarantee, public company limited by private unlimited company, and public unlimited company. However, the entities was extended to just 1 category. Under CAMA today, there are 3 kinds of companies under this category. We have the single member company or the 1 shareholder company, the small company limited by share, and that unique species of companies that CAMA refers to as companies limited by shares other than small companies. That is the language the law uses in describing them. Into that category, you have the medium to large private companies limited by shares. A typical example would be something like maybe Intel or any other fairly sized company that does not qualify as a small company under section 394 of CAMA. So only private companies, only small companies and single shareholder companies are exempted from the obligation to hold annual general meetings. In relation to single member companies, it is almost obvious why they cannot hold annual general meetings. The reason is this: a man cannot have a meeting with himself. It takes 2 to meet. It takes 2 to tango. So a single member company, a man cannot fix a meeting and have a meeting with himself. Therefore, it will be ludicrous, to even conceive of it, that he'll be obliged to hold an annual general meeting. Now, we move further. The annual general meeting is specifically intended to transact certain businesses of the company. Under the law, there are 2 kinds of businesses that can be transacted at the annual general meeting. We have the ordinary business of the annual general meeting and the special business of the annual general meeting. As a general rule, all businesses to be transacted at the annual general meeting of the company is all businesses are special business, except the ones that are accepted under section 238 of CAMA. And these include 1, the presentation of the financial statements and the reports of the directors and auditors. 2, the declaration of dividend. 3, election of directors in place of those retiring. 4, the appointment, fixing of the remuneration of the auditors. And then 5, appointment of members of the audit committee. Finally, disclosures of remuneration of managers of a company. A careful read of CAMA will sometimes reveal to us that in addition to these ones that are stated under section 238 of CAMA, there are also variances of them that CAMA recognizes that can be taken as ordinary businesses of the AGM. They include, for instance, removal of directors, removal of auditors. These ones are not spelled out under section 238, but they are referred to in other sections of CAMA, and I have taken them there. Now, in terms of the business of the annual general meeting, the company limited by guarantee, by law, cannot strictly comply with the entire provisions of section 238. And the simple reason for that is this: it cannot declare dividend. So for purposes of compliance with section 238, every company limited by guarantee will comply with 238 to the extent that it is required to declare a dividend, because 1, companies limited by guarantee do not have share capitals and therefore do not have shareholders. And they are formed for the promotion of commerce, art, science, religion, sports, and so forth. So they are not into the business of making profit, as it were. Therefore, they do not have to be seen to pass a resolution approving the payment of dividend. Now, another area of the law regarding annual general meeting is of keen interest is the area that has to do with the venue of the annual general meeting. Every annual general meeting and even statutory meetings in Nigeria must be held in Nigeria. There is also the exception of the private company limited by the small company and the single member company, but for us, it is not very material. Every company in Nigeria, save for those accepted, must hold their annual general meetings in Nigeria. And in terms of the conduct of the business of the annual general meeting, we have had a bit of legal innovations. Before now, under 2004 CAMA, companies in Nigeria were only permitted to hold annual general meetings physically. No provision was made for electronic participation or virtual meetings. In 2020, however, following the repeal and the reenactment of CAMA of that year, we now saw the innovation to have meeting. But that in itself also was inadequate because that followed in 2020, such that even though the SEC and other sectoral regulators try to ensure that public companies could hold meetings and have an arrangement where there are designated proxies that people must appoint as proxies and then have no more than 7 persons at an AGM. The wisdom of enlarging that liberty to have electronic meetings, even for public companies, was now made part of our law in 2022, following the enactment of the Business Facilitation Miscellaneous Provisions Act number 5 of 2022. What that means is that effective 2022, public and private companies in Nigeria are now permitted to hold virtual general meetings in addition to physical meetings, okay? So now the next area of concern is how an annual general meeting is called. Essentially, a notice of annual general meeting is usually issued to convene an annual general meeting. Under Nigerian law, the notice is said to be for 21 days. And in the computation of 21 days, the date on which the notice is given is excluded, and the date for holding of the meeting is equally excluded. So we are talking about 21 free days between the day the notice was issued and the day of holding the meeting. However, the law says that failure to give notice usually generally could be fatal to the general meeting, but creates an exception. And specifically in relation to annual general meeting, the exception created is that if all members of the meeting execute a consent to agree to a meeting called on shorter notice, then the meeting becomes regularized or valid. In other words, when the meeting is convened on shorter notice less than 21 days, all the shareholders present will be made to sign a consent to shorter notice form saying we consent to the calling of this meeting for a period less than 21 days as required by law. Whatever the format is, but that is the effect in law. It regularizes the meeting so that the meeting can proceed to business. Now, the notice sent out to members of the company must specify certain key criteria or requirements as stated under section 242 of CAMA. The notice, for instance, must specify the place of the meeting, the date of the meeting, the time of the meeting, the general nature of the business to be transacted, and sufficient decide whether or not to attend the meeting. And then it must also state that if a special resolution is to be passed at that meeting, the details of those resolutions, not just to say to declare dividend, to pass, to appoint director, no, the details, the draft of the proposed resolution of that special must form part of the content of the notice that will be sent to all shareholders. Then now, in every notice calling a meeting of the company having share capital, this is very important. The law requires that the notice must also contain a notification to all shareholders, particularly in a company having shares, a notification to all shareholders that they have the power or the right to appoint proxies. Proxies is a very big business when it comes to general meetings of companies limited by shares, because implicit in the right to attend, speak, and vote at general meetings, or consistent with the right of membership of a company limited by shares, is the right to appoint a proxy, and the proxy need not be a member of the company. He would, at the time of attending the meeting, have every right as that member to speak, to vote on any issue that has been placed before him. The law regulates also how the proxy form is to be delivered, but I believe when my notes get to you, the details of that will be explained. So we now come to the question, who is entitled to notice of the annual general meeting? Now, to whom notice will be given, that the issue of entitlement to notice is governed by section 234 of CAMA. And the law says that the following persons are entitled to receive notice of annual general meeting. They include every member of the company, every person upon whom ownership of the share devolves by reason of being a legal representative, receiver, or a trustee in bankruptcy of any member of the company. Obviously, by the time they use the word devolve, you know that we're talking about upon their transition or some other happen chance that the law recognizes. Then every director of the company, every auditor for the time being of the company secretary, and in the case of public companies, the commission. One thing I would like to state here is that although these are the persons CAMA says must receive notice, from a practical standpoint, we have seen that other sectoral regulators of public companies sometimes make it mandatory that even the notice to be sent to shareholders, a copy of it must first be sent to them for approval before you can convene or call that meeting. So although CAMA has stated in section 234 that to the extent that notification will be given to anybody other than this person, just the commission, it may be enlarged when you consider other laws. So the question now is, how is the notice of meeting sent to members? Under section 244 of CAMA, before now, the notice could either be personally, but we have had an amendment to the law, like I said, the Business Facilitation Miscellaneous Provisions Act of 2002 has enlarged the number to about 4 persons. So we can have notices sent personally to them, now sent electronically to them, or it can be sent by post to their registered address, or it can be delivered. In case that this, the 4th item relates to shareholders who are not domiciled in Nigeria, but have provided an address for receiving of notices in Nigeria, it can be delivered to their address. So delivering to their address is considered by law to be good service or delivery of the AGM notice. Now, at the AGM at the AGM meeting, one of the transactions that would normally be conducted is the voting. Voting is a very integral part of the AGM. Now, every member who is entitled to receive notice of meeting by law has the right to attend the meeting and vote at that meeting, subject, however, to the provisions of Section 107 of CAMA. The section actually creates a clawback to the right to vote, but I'm sure when you look at it, you understand what it means. What it says is that it recognizes the right of all shareholders or members of the company to, shareholders now, to attend, speak, and vote at meetings of the company. However, the articles of association of the company may create a restriction to the effect that shareholders who have not made payments on calls or have payments due and payable on their shares may have the right to attend, or if it is not the right to attend, the right, if they can attend, the right to speak or vote restricted at the annual general meeting. So subject to that provisions in the articles of association, every member of the company that receives notice of meeting has a right to attend, speak, and even vote on the issues that are presented for discussion. Now, in terms of voting, there is also an amendment to the law because of the 2022 Act, the Business Facilitation Miscellaneous Provisions Act number 5 of 2022. And that is, before now, voting could either be by way of show of hands or by a poll called at the appropriate time. However, with the fact that electronic participation in AGM has been incorporated into 3 forms of voting to take place during the AGM. Now, the law is that unless a poll is demanded in the meeting within time, either before the resolution is put to vote, or if the vote has taken place before the result is, when the result is declared, before the winner is announced, a member of the company can demand to have a poll. For those of you who have not really associated, mentally associated with what the poll is, consider the election we had during 2023, where you go to a polling unit. A poll simply means that they will conduct a poll, and the pattern of voting during the poll is that every vote held by a shareholder counts for purposes of determining the swing of the vote. So if a shareholder has 3 million shares in the company, then he has 3 million votes should he decide to vote on a particular topic. So it is counted in that manner. So then there is also the declaration of results. Results are declared by the chairman of the company, who presides over the meeting. Usually, when the results are declared, the chairman would declare that a particular resolution is carried either by a unanimous majority, a simple majority, or completely lost. The same declaration is done even when the poll is taken. So voting is one of the key rights, core rights of shareholders during the annual general meeting of the company. And that beyond annual general meeting, the same right extends to all meetings of the company, provided they have the right to attend and vote. They have the right to receive notice and attend. They have the right to vote at those meetings. But we are limited to annual general meetings now. So we now have to consider what is the effect of a failure to serve notice of meeting. The law is not silent on the consequences of a failure by the company to issue notice of meeting. Section 254, subsection 1 of the Act is authority for the proposition that the failure to give notice of any meeting to a person entitled to receive it invalidates the meeting, unless such failure is an accidental omission. What it means is that generally every fact, the mistake, if it can be excused as an accidental omission on the part of the person responsible for issuing the notice, and that can be proved, then it will not be fatal to the meeting or the entire business of the AGM that be transacted. Judicial authorities are bound to support this proposition. The position of the law was restated in the case of Oteri and Holdings. Oteri Holdings Limited, Monfa West Africa Limited. The citation is there. And my Lord, the Honorable Justice Onyekachi Aja, JCA, literally restated what Section 245, subsection 1 of CAMA says when he said, failure to give notice of a meeting to a person entitled to receive shall invalidate the meeting unless such failure is an accidental omission on the part of the person giving the notice. There is a consequence at the company meeting of the AGM itself. You know, if the company fails completely to hold the annual general meeting, the law says under section 237, subsection 5, that the director, the company, the director, and every other person who knows can be liable to sanction by the CAC. So that is that. Now we will now come to one very crucial aspect of the general meeting. And this question, this aspect answers the question, why is holding an annual general meeting important? So the first reason I can easily think about is that compliance, well, holding the annual general meeting, you know, ensures compliance with legal and regulatory requirements, governance, but a legal requirement for companies. CAMA mandates that companies must hold AGMs to fulfill legal and regulatory obligations. This requirement is in place to ensure that companies operate within legal framework and provide stakeholders with the necessary information and opportunities to exercise their rights. So a failure for a company, by a company to hold annual general meeting is usually greeted with sanctions under CAMA, as we have stated under section 237, subsection 5. Another very important reason why the AGM is important is that it strengthens stakeholders' engagement. How does this happen? Stakeholders' engagement would involve a question and answer session. The board makes its presentation to the members. The members ask questions to fully understand what has been happening to their investment, fully understand the trajectory of the company, and the level and style of management of its affairs. So AGMs provide a unique opportunity for companies to engage with their stakeholders and foster a sense of community. Shareholders, being a vital part of the organization, can actively participate in discussions, ask questions, and provide valuable feedback. This direct interaction allows shareholders to feel connected to the company's vision, strategy, and performance, ultimately fostering true trust and loyalty. If you remember, sometimes as part of the shareholders of the company, there will be institutional shareholders. If you remember who they are companies and other institutions that have vast control of resources and a lot of experience in terms of industry and business practices. So having them sit at your annual general meeting to indulge in that kind of exchange, essentially strengthens stakeholders' engagement. They are happy to know that they can play a role, and then stakeholders have a sense of commitment to the company. Now, ensuring transparency and accountability is my third reason. Transparency is the cornerstone of healthy corporate culture. AGMs facilitate the disclosure of critical information, such as financial statements, annual reports, and executive remuneration. These disclosures enable stakeholders to assess the organization's financial health, understand its performance, and evaluate the effectiveness of its management. Furthermore, AGMs provide a platform for shareholders to hold the board of directors accountable for their decisions and actions, ensuring responsible governance. 4, decision-making and voting. Now, AGMs serve as a forum for making important decisions that shape the organization's future. During these meetings, shareholders have the opportunity to vote on key matters such as electing or removing directors, approving financial statements, and ratifying auditors' appointments. The rotation of directors and election of new directors and auditors is a feature of the AGM, and it serves as a form of succession planning for the company. So, right. This democratic process empowers shareholders to have a say in the company's direction and aligns the interests of all shareholders. Moreover, voting results serve as a measure of shareholder sentiment and guide management's decision. If you attend a general meeting and the shareholders are not pleased with your performance, tell me why they would want to re-elect you as a director on the board of that company. Shareholders use the instrumentality of voting as a means of making their statements or sentiments loud and clear. They use it to not only approve the strategic plans and focus of the company as are contained in the audited financial statement, but they use it also to discipline their board, to show their resentment, and in some cases, to endorse their approval of their wonderful performances over the company's affairs. So we also have strategy and goal setting. AGM provides a platform for companies to communicate their strategic plans and goals to shareholders and stakeholders. The transparency helps align expectations and ensures that all parties are on the same page regarding the organization's visions and objectives. Through discussions and presentations, AGMs enable shareholders to get insights into the company's growth strategy, risk management, and market outlook, fostering a shared understanding and commitment towards achieving long-term successes. You will recall that the chairman will always give there's always a director's report to be presented as part of the documents in the AGM. Many companies use the director's report and other statutory reports that they make to give the futuristic outlook or strategic focus of the board. All of this will be explained and defended before the shareholders. So by so doing, shareholders understand the trajectory of the company into the foreseeable future. There is also the advantage of corporate social responsibility. AGMs offer an opportunity for companies to showcase their commitment to corporate social responsibility initiatives. By sharing updates on sustainability efforts, environmental initiatives, and community engagement projects, organizations can highlight their contributions beyond financial performance. AGMs serve as a platform to discuss CSR strategies, seek feedback, and involve stakeholders in sharing responsible business practices. Then there is also networking and relationship building. This is at the very social and business level. The AGM affords opportunities to shareholders to speak with other shareholders. Shareholders who are congregated at those meetings come with a diversity of backgrounds. Some are captains of industries in sectors that will be appealing to other shareholders who are meaning to go into them. Some are also, practitioners in areas that are familiar, but from where a shareholder can benefit through their shared experiences. So the opportunity for networking and relationship building, usually survives and transcends beyond the AGM. Relationships are built, business relationships, personal relationships can transcend the curtilage of the general meeting room. So we also have shareholders education. Not many shareholders come to the AGM meeting with vast experiences of knowledge. Some people are shareholders by virtue of the fact that they have bought shares, and that essentially is the minimum qualification to become a shareholder of a company. However, it doesn't mean that they have technical knowledge, competencies, and skills regarding how certain things are done, or even the conversations that take place. So the explanations or reports given to shareholders by the board of directors help to fill that void. It is educational. It creates awareness about certain areas of the company's operations. And then also that exchange of information equips shareholders with a deeper understanding of the company's activities. Then the ninth reason I can give is it enhances investors' confidence. A company that regularly hosts its AGM meeting is more alluring, attractive to investors, because it means that management has not jumped ship or jumped overboard. The company continues to survive, sustain itself as a going concern, and is following its strategic, tactical, and short-term goals. So shareholders or investors who are invited to such meetings and they see that the company continues to meet, continues to work on his business blueprint, are more, persuaded to invest in those companies or do businesses with those companies. Number 10, addressing concerns and feedbacks. The shareholders meeting or the annual general meeting is the most critical opportunity that shareholders have to express their concerns, to speak their mind, their reservations about the management of the company, the business of the company, or matters that affect them personally in relation to the company. It is also an opportunity for the board as the head of the management to take feedbacks from the shareholders so that they can translate these feedbacks into directions of action that will address the concerns of the shareholders. Then 11, evaluation of corporate performance, the point where the scorecard of the shareholders are read, the directors are read. AGMs afford an opportunity to evaluate the company's performance against its stated objectives and goals. By presenting financial statements, key performance indicators, and future plans, the management can demonstrate the organization's progress and achievements. Shareholders can assess the company's financial health, profitability, and efficiency, and provide valuable input on areas that require improvement or strategic adjustments. So, lastly, we have compliance with shareholders' rights. We have repeatedly said here that consistent with the right to receive notice of meeting, consistent with the right of being a shareholder, is the right to not only attend the meeting, speak at the meeting, but the right to vote. Any company that chooses not to hold an AGM is depriving his shareholders of the right to attend the meeting. That is a right implicit in their shareholding, the right to speak at the meeting, and the right to vote, to take decisions that would affect the operations of the company. So that is that on the AGM. We'll now come to the area where I feel we don't really have much time. Sorry about that. So we now come to the area of organizing the annual general meeting. Ladies and gentlemen, for an annual general meeting to be successfully held, a lot of preparation goes into it. You know, like I said here, one can never truly overemphasize the necessity for so much preparation. Preparation, planning, and execution on the plans are necessary ingredients for a successful AGM. Now, the company secretary plays a very active role in that entire process, you know, because essentially he is the chief compliance officer of the company, and by his statutory duties, he is positioned in such a manner that he is able to render those services or support in terms of organizing the AGM. Section 335 of CAMA makes it clear that part of his statutory duties include attending the meetings of the company, the board of directors, its committees, render all necessary services. They are all there. The responsibilities or duties of the company secretary are stated there. So the question is, what are the key steps that the company or the company secretary must ensure in, or the company as an entirety will have to observe in convening the annual general meeting? There are many things that will be done, but I am focusing on the major ones. The first of these ones will be to convene the pre-AGM board meeting. Now, I say pre-AGM board meeting because it's a very vital meeting of the company. It is the conduit point, the junction point where all the directions regarding the holding of the AGM. So essentially, when the board hosts its pre-AGM board meeting, some of the things you will see come as the outcome is that they approve the audited financial statement that the company secretary has provided, and even authorized 2 of their members to sign the account. You'll see this in section 386, subsection 4 of CAMA. Then also, the dividend decision is taken by the board at that meeting. The board members will recommend whether to pay or not pay dividend based on the performances of the company. That particular decision comes at the time the account is approved for implementation. Also, a draft of the director's reports, you know, that is prepared, that will be read at the meeting, which is one of the statutory reports, will also be reviewed, vetted, approved, and endorsed for inclusion in the audited accounts. Then we also have the approval of the draft statement of the director's responsibility. All other statutory reports that should accompany the account will be considered at the pre-AGM board meeting. The pre-AGM board meeting also does a vital thing. That meeting is the position where the company fixes the dates, venue, and time for the next annual general meeting of the company. They must decide that at the pre-AGM board meeting. Once that is done, every other thing that follows is implementation. Okay, so now after step one, the next thing that the company will have to do is to approve a budget for the AGM. This is very, very important because the budget is intended to capture all the variables that will be necessary to be put in place and to assign costs to them. So during the budgetary provisioning, costs will have to be allocated to production of the finalized accounts, the cost of the venue and maybe the decoration, the cost of advertisement in national dailies in terms of public companies and all of that. We also have the cost of postage of AGM, cost of configuring virtual participation platform, and all of that. So cost will be assigned to every variable. If electronic voting will be permissible, the cost of setting up the electronic platform. If we are going to have media coverage, live media coverage, the cost of it, we need to have a budget to cover all of this. After the budgeting stage comes the implementation. Implementation, taken in no particular order, would include, for instance, sending a draft of that notice approved by the board to SEC or to the Nigerian Stock Exchange or to the CBN, depending on the sector regulations in the case of public company for approval. Once it is approved, then the company can now come and issue the notice to its shareholders. The notice will then include, in some cases, the CVs of the directors to be appointed at that meeting for consideration by shareholders. All the statutory reports will accompany the notice. And then the notice will be advertised in 2 national dailies for public companies and sent to friends of the companies and all of that as will be required. Then the venue of the meeting. The company secretary will ensure that the venue has been designated for the meeting is paid for, and to ensure that the venue meets a lot of criteria. In terms of the venue, okay, sorry. The venue. I said this so that at least we can be on the same page. Ensure that the pre-qualified venue can be easily located by members attending the meeting and accessible to even physically challenged members of the company. This company secretary for the purpose for the meeting and that it is secure and private enough. In this regard, he is required to pay several visits to the venue ahead of the meeting and to vet and ensure the following, among others, that the lights in the venue are in good working condition and that the venue is not too brightly lit. Or to dim. He has to make sure that, adequate power supply, and then as a condition that the proper used by the shareholders and that the toilet facility. These are things that you would consider to be pedestrian, inconsequential. They are very material for the purpose of convening the annual general meeting of the company. So you have public address system, projectors, microphones, and all other. They must be in working condition and must continue to be in working condition before and during the meeting. So yeah, I'm sure when I share my notes with you, you will see how much will go into the execution of the entire process. But suffice to say that even at the venue, you must ensure that the register of members, okay, register of members, the register of directors of the companies at board meetings are provided these are all statutory documents that the law requires must be at the meeting, kept open for inspection by members. Then there's also need for contingency planning, and if necessary, make provision for another venue in the unlikely event that you have issues with that particular venue. Company secretary must ensure that for purposes of documents that will guide the process, this would include the memorandum and articles of association of the company, a copy of CAMA for quoted companies, the Stock Exchange Code of Corporate Governance, Financial Reporting Council of Nigeria Act, listing rules, NSC, that's the Green Book, SEC rules, so many rules that will guide the process. And also these statutory registers that must remain open during the board meeting. They are necessary because sometimes these meetings can be faulted by somebody and cause problems in the future. We now come to manage the conduct of the AGM. I hope, Moderator, you will spend some time here. But in terms of managing the conduct of the AGM, essentially the responsibility of managing the annual general meeting of every company falls to the chairman of the board. Okay. Now, before that is even done, on the day of the annual general meetings, the tables are open for members to be registered, guests to be registered. Now, the registration of members at the desk, the secretarial desk, information gotten from that point is usually transmitted to the company secretary before the commencement of the meeting. You will find out the reason in a short while, but essentially it relates to quorum of the meeting. Now, the structure of an AGM essentially follows this pattern. You know, one, we have the registration of members and guests. Two, quorum and call to order. This now we're going to the business. Three, presentation of the board chairman, other members of the board and board committees, senior management, the company secretary and external auditors. Four, chairman's welcoming remarks. Five, reading of the notice convening the meeting and adoption of its agenda. Six, presentation of financial reports and other statutory reports. And once that is done, we now have votes and elections coming up. Before you have your closing remarks, your vote of thanks, and then the meeting is adjourned. Now, so like I said, the responsibility of managing the AGM falls to the company, the chairman of the board. But the chairman receives ample support from the company secretary, who must not only prepare the company chairman in terms of what to say at the meeting, but also be there to provide quick answers to the company chairman when naughty questions are asked by members from the floor of the house, and they must be answered. They must be managed. So he assists the chairman by providing answers to the questions. Now, in terms of conducting the general meeting, one thing that the company secretary, and I'm speaking to all of us, must always do is to prepare a guidance document, which is sometimes called the order of proceedings of the AGM. This document essentially speaks to word for word what the AGM, the chairman of the meeting, would say, and governs the process such that it allows for the board, the chairman, to maintain the democracy of the meeting, while at the same time eliminating distractions and control. So the order of proceedings essentially has this structure, okay? And it is provided exclusively for the chairman's use. It's not a document to share with everybody. It includes a call to order. Once the meeting is called to order, the chairman could say something like, "It is now 10 o'clock. This meeting is hereby called to order." That signals the commencement of the meeting. It is contained in the order of proceedings, and once he does that, the meeting is said to have officially started. The next order of business is the confirmation of quorum. Now, it is important because unless a meeting is quorate, the meeting must stand adjourned. So the meeting is called to order, the chairman confirms quorum. If there is no quorum for that meeting, the meeting is adjourned to another convenient day, maybe 30 days from that day. And if on that day the quorum is still not met, then the number present will constitute the quorum. But the only power the chairman will have if quorum is not formed on the day of the first meeting is the power to adjourn the meeting, to declare that a quorum has not been formed and adjourn the meeting. So quorum must be present. And the procedure is this: before the quorum, the meeting is when the chairman calls for quorum, you remember the secretariat would have assisted the company secretary, by providing the information, the total number of members who are registered for the meeting, who are in attendance. Now, the information would include members who are physically present, those who are participating electronically, those who are represented via proxy. They will all be spelled out. and then he will advise the chairman that the quorum has been formed based on compliance with the articles of association of the company. Then the chairman now proceeds with the business of the company. For some chairmen, they would want to start with the national anthem. These things are not in any company, and they are not in the act, but it's a procedural ritual, national anthem or opening prayers. Whichever the chairman prefers, he calls for it. And once that business is done, the chairman will now introduce members of his own board. He introduces members of his board, to the general meeting. He introduces members of his board to the general meeting, and this will include directors, and he's mindful to specify if they are executive and non-executives, and if they are executive directors or non-executive. If they are executive directors, he's also mindful to state the positions they hold in the office. Where they are non-executive directors and they hold offices in board committees, he's also mindful to state that as well. He introduces members of management and then goes on to introduce the company secretary, the external auditors, and members of the company's audit committee. And then also, in situations where you have sectoral regulators in attendance, he goes through the compliments of recognizing them, and maybe guests. Guests may include investors that the company has invited to be part of the meeting. These guests will have to be introduced or acknowledged as well. Now, after that is done, the chairman calls for the reading of the notice of meeting. Now, remember, the notice contains the agenda or business of the meeting. So the company secretary reads the notice of meeting, or in some cases, a motion is taken that the notice of meeting, which had formed part of the documents sent to the shareholders, be taken as read. If that is approved, they jettison the need of reading the notice. But if the company insists that the notice be read, then they will go on to read the notice. So after reading of the notice, an motion is taken adopting the agenda for the meeting. Then comes the presentation of reports. The reports are taken one after the other. The chairman will make an invitation to each member, each presenter to come forward and present his report, commencing with the financial statements of the company, the report of the directors, the reports of the independent auditors, the report of the independent auditors and all that. So it will be taken, and at the end of the day, when all the statutory reports have been taken, votes. The chairman will now call for
Yes. Yeah. Sorry, dear participants. There appears yeah, there was a slight glitch. Hello, everybody. Hello.
I can hear you.
There was a slight glitch, and I think
I can hear you.
we lost our presenter. We'll get him back shortly, please. I'm sure I'm still with you. Yes. So if we just can be a bit patient, the presenter's internet facility just gave him a slight problem. He'll be back shortly. Hello, Mr. Eyidengha. Hello, sir. Can you hear us? I think you're muted. Can you hear me? I think you're muted.
I can hear you loud and clear. My apologies. I'm just having some
hear you now.
Hear you very, very well.
I can hear you now.
Can you hear me now, sir? My apologies. Okay. I
I'm
sincerely
sure
apologize. I'm having some fluctuations at my end.
Sorry about that. Sorry. Yeah, you may proceed.
Problematic. Can you hear me, sir?
Yes, I can. I'm sure we can all hear him.
We can all hear you. We can all hear you loud and clear. Please proceed.
Yes, we can hear you.
All right. Please, I sincerely apologize. There are certain things that are literally beyond my control right now. Chief amongst them is how my network behaves.
Sorry about that.
All right, let me just share my. So, all right, thank you very much. So I can't even tell where exactly you left off. You know?
Yeah, I can tell you you are actually concluding.
Thank you. Thank you. So essentially, after the reports, the procedure is the chairman takes all the reports by all those who have reports to produce. The statutory audit committee, the report of the independent auditors, report of the directors, all statutory reports in the accounts are read to the members of the company. After that, the chairman invites for comments, and the invitation for comments, observations, and questions are consistent with their right to speak, to ask questions during those meetings. When the comments, observations, and questions are asked, the board responds to them. The chairman may directly respond or invite others to respond to the questions. After the questions have all been addressed, the chairman of the board will now turn to the core business of the meeting, which is as contained in the notice convening the meeting. And it will start with laying the accounts for the preceding financial year before the members, for them to vote. So the board seeks the approval of the members on the accounts. Now, members will vote. The vote will be by show of hands. So the procedure is that unless the chairman is a shareholder or a proxy to a shareholder, he will not propose the motion. He will not move for a motion to be. Only members can do that. So the chairman, if he's a shareholder, will say, he could take up the initiative and say, I now propose that the audited financial statement of the company, together with the director's report, the independent audit report, and this, that, for the financial year 2003, as laid before the members, be and is hereby approved. If he makes that proposition, somebody seconds the motion. Once the resolution is seconded, he could call for comments at that point. If there are none, they proceed to the vote. All those in favor say aye. Hands, it will be by show of hands. The secretariat will count the total number of votes for and the total number of votes against. Once the votes are taken, the result is declared. If it is unanimously approved, it is so stated. If it is approved by a specific majority, it is so stated. If it is lost, it is so stated. That ends that business under the law. The next resolution will be called for and taken following the same pattern. If it is for the appointment of directors, depending on whether it is a public or private company. For private companies, the company can decide to take the appointment of all the directors in one fell swoop, one stroke. I hereby propose that Mr. A, B, C, D, E, F, G directors who are now retiring and being eligible for re-election be hereby reappointed as directors of the company. They will go through that process. Votes will be taken and recorded. Okay, so this will be the process, and then audit committee, the appointment of the auditors, if that is a matter on the subject on the list, everything will be taken. At the end or conclusion of the voting process, the chairman will now call for remarks or comments from members of the floor procedurally. If none is there, the chairman will now appoint any member of the floor to give a vote of thanks. Once the vote of thanks is given, the chairman calls the meeting to a close and adjourns. So that is essentially the structure of the annual general meeting. Now, some of the safeguards that the company secretary must ensure is that one, no business will be taken at the annual general meeting for which notice has not been given to members. That's number one. So members cannot on the spot raise issues that are not contained in the notice calling the meeting, except there is provision for any other business which is not even a statutory provision. So no business can be taken, and when I say business taken, resolution taken on any matter that is not itemized as a business of that meeting. So these are the things the chairman and with the support of the secretary must ensure. Order, control until the meeting is concluded. So having done so, we now come to the area, the area that is a bit naughty for everybody, the issue of the compliance conundrum. And my reaction to this is simple. The company as a company, has an obligation to conduct its annual general meetings, So, however, although some company secretaries are skilled and they seem to know how to navigate their way around, there is always a challenge regarding AGMs. And the challenge is this: what laws how do I get to know what laws that apply to me? Typically, everybody looks to CAMA as a governing document for AGM, but it's not always the case. And the reason for this is simple. Various rules of law apply to various companies, depending on the sizes of these companies, the nature of business of these companies, the sector or industry of operations, and even the complexity of their operations. I'll give you a typical example. A company limited by shares or a private company limited by shares will not observe the level of procedural requirements that will be demanded of a company, public company limited by shares. The regulators are more, the regulators are overarching, and they have made regulations and guidelines. So when you talk about the conundrum of compliance, essentially the first signal and the major signal to the conundrum of compliance lay in the fact that factors such as size, nature of business, sector of operation, and operational complexity impact the level of compliance to be observed in relation to each company. Okay, like I said here, put differently, compliance have different levels of regulatory. Companies have different levels of regulatory compliance, obligations when conducting their AGM due to a difference in their size, sector or industry of operation, nature of business, and complexity of operations. Thus, a one-size-fits-all approach when it comes to AGM is totally inadequate and not feasible. Therein lies the conundrum when it comes to compliance with the rules. So, for instance, a mid-sized private company like a bakery proposing to hold its AGM may simply have to contend with complying with its articles and the provisions of CAMA to guide the conduct of its AGM. However, a listed company like a commercial bank will need to comply with its articles, CAMA, ISA, that's the Investment and Securities Act, Securities and Exchange Commission's rules and regulations, Nigerian Stock Exchange rules and regulations, CBN Act, BOFIA Act of 2020, Nigerian Code of Corporate Governance 2018 as incorporated by reference by the Corporate Governance Guidelines issued by the CBN in 2023, and all other guidelines issued by the CBN from time to time before it can hold its AGM. Now, the reason for this is this. I have read through most of these laws, particularly in relation to banks. One of the, regarding the business to be conducted at the AGM, you cannot, for instance, contemplate appointing directors without seeking the approval of the CBN. You must write to CBN, send the particulars of the director to CBN for vetting. They will do their security check, do their due diligence on that director, and if they have no objection, they will give you a letter of no objection before you can proceed to appointing the director and presenting him to the board for approval. The same thing applies to the auditors of the company. If you go through section 28 of the BOFIA, you'll see that for you to appoint the auditors of the company, you must seek the prior written approval of the CBN. So these ordinary businesses of the AGM, you must have to check. And then also, there are requirements about publication. If you must have your AGM, you must publish on your platform, on the portal, Nigerian Stock Exchange portal, the notice to that effect. Your notice of meeting must be there. You must also publish the notice in your own company's website. That will go around. So compliance monitoring, observance of compliance is a function of the nature of the company, the size of the company, the sector of operation, the type of company, and the complexity of its operations. So the final question I ask in relation to this topic is, how does the company secretary overcome this conundrum? If he is thrust in a situation where he is engaged as the company secretary of the company and must hold his first AGM, what are the things he has to do to make sure he covers the scope? I propose two solutions. The first of two is KYC, know your company. What does that mean? The company secretary must have a very thorough understanding of every facet or particular of his company. And in this regard, the company secretary must know the type of company, that is, whether it's a company limited by share, limited by guarantee, or unlimited, because the rules differ in terms of that as well. For instance, we have identified that a company limited by guarantee cannot discuss anything about shares because it has none to discuss. These things, the company secretary must be mindful of them. Then we need to find out the category of the company, because the category that the company is identified to belong to, whether it is a private company limited by share, or a private company limited by share other than a small company, a public company limited by share because different rules will apply, a private company limited by guarantee because the rules are different, public company, like that. You need to identify the specific category of company. Having done that, the company secretary, if it is a public company, must need to determine whether the public company has shares and whether its shares are traded on the stock exchange. Not all public companies are listed. Epenet boat builders in Port Harcourt is a PLC, but it's not. So its level of compliance will have limited application from the Nigerian Stock Exchange, which also provides guidelines for them. Now, hello, gentlemen, can you hear me?
Yes,
We can
yes,
hear
we
you, sir.
can.
Yes,
Yes, we can.
We can hear you.
Thank you. Now, whether the company is incorporated under CAMA and therefore subject to the laws within the customs territory, or it is a specialized development, it's in a specialized development zone, such as the NEBSA free zone or the oil and gas free zone here in Port Harcourt, which have their separate set of laws affecting company regulations. The NEBSA, the Eco-Atlantic Free Trade Zone Regulation 2019, spells out what the company must do to conduct its AGM. It goes to the nitty-gritty. This is not CAMA, because CAMA has no place in any of these specialized zones. Yet, by law, they are companies. So if you find yourself in any of these frontiers, you need to know the laws that apply to them and how to navigate them. There is also, you need to know the sector of operation, the sectoral regulators relating to certain sectors. Banking is CBN, insurance is the NICOM, pensions is PENCOM, telecommunications is NCC, commodities, and they all have their regulators. Some of them that don't have specialized regulators will fall back to SEC as regulator. And when they are quoted on the stock exchange, NSC provides, the Nigerian provides regulations for them. So the regulators overseeing each sector, like I said, the regulator overseeing each industry or sector, and the specific regulations they have made regarding companies under their supervisory purview, especially as it relates to convening and conducting their AGMs. And then you need to know the nature and complexity of the business they do. For instance, if you consider the Nigerian Code of Corporate Governance 2018, typically you would say it applies to public companies alone, right? But if you go to the area when it comes to application, you will notice that it also applies to certain kinds of private companies that have transitioned from government ownership to private ownership, with government creating supervision for them. Those kinds of private companies also must fall back on whatever their sectoral regulator would have provided in terms of how to conduct meeting. After you have identified or come to know thoroughly your company, ladies and gentlemen, your second next step in trying to beat the compliance conundrum is to do your own research. What does this mean? You now know that your company that is limited by guarantee, or your company that is a PLC, that is a bank, must be regulated by the CBN in addition to the NSC because it is listed. You must take your legal research in terms of compliance to these areas. Read everything you can read about what they have said regarding how to conduct AGM, if they have so provided regulations for one. So like I said, there is no substitute for diligent and thorough legal research. The company secretary, having determined the nature of the company he is engaged in, must dig deeper to know the laws, rules, regulations, and guidelines that apply to the company's operations, and whether the regulations make provisions regarding convening and conducting annual general meetings or any business to be transacted as such meetings. The company secretary of a listed company, a listed commercial bank, for instance, would have no excuse for not fully reviewing and undertaking the following laws. Look at what I've written there: the CBN Act of 2007, BOFIA of 2020, Nigerian Code of Corporate Governance 2018, CBN Corporate Governance Guidelines for 2020 to 2023, NSC listing rules, the Green Book, Investment and Securities Act, SEC rules and regulations, SEC corporate governance guidelines, companies and allied matters, and so on. You must cover the entire framework of regulatory compliance to properly prepare you for guidance in the convening and conduct of your AGM. And finally, ladies and gentlemen, the company secretary is at liberty to ask questions from fellow secretaries and other professional colleagues engaged for guidance on applicable laws and procedures in handling the annual general meeting. If there are no knowledge gaps that his studies have proved inadequate to fill, after all, no secretary is an island unto himself. Ladies and gentlemen, on that note, I bring us to the conclusion of our paper. And I have said, unless all companies in Nigeria must hold their annual general meetings each year or face legal sanctions for their non-compliance, organizing and managing the annual general meeting requires delicate preparation and planning, as well as meticulous implementation. Since the existing rules that govern companies' AGMs do not apply evenly to all companies due to considerations of type, size, industry or sector, and complexity of business operations, the conundrum of determining what rule a company should apply is therefore created. As the Chief Compliance Officer, the company secretary who is beset with this compliance conundrum overcomes it through an in-depth knowledge of the unique features or attributes of his company, and complements this knowledge of the company with an equally in-depth research into the applicable laws, rules, and regulations that apply to companies bearing such attributes. And until that is done, the fear of penalties for non-compliance, including invalidation of the entire meeting process, will continue to cast a shadow over the AGM. Ladies and gentlemen, that concludes my discussion on this topic, and I thank you for listening. Mr. Moderator, over to you.
Thank you so much. Thank you, Mr. Eyidengha. It was quite revealing, and I'm sure our friends and colleagues here will go home richer, more enlightened, and quite grateful that they are here today. Would now give the next 10 minutes to take questions. If you have any question, you may unmute yourself and right away ask the question. The floor is now open for questions, please.
Okay, good evening, sir.
Yes.
Yes, thank you so much for a very wonderful lecture. I'm grateful for this opportunity. So my question is on the...
Sorry, please. Just mention your name and where you're coming
Okay,
from.
my name is Ruth Kenebo Itama. I'm based here in Port Harcourt. Yes.
Yes.
So my question is with respect to, okay, speaker mentioned procedures for appointing new directors with respect to certain publications, applications to CBN and all that. So I want to know if there are stringent procedures as it relates to appointment of a company secretary.
All right. Thank you. Should I take other questions or?
Please, yes, Mr. Eyidengha, you just wait a bit. Okay. If there's any other question, please indicate. So we'll take all of them together.
Hello, good afternoon.
Yes.
My name is, can you hear me, please?
Yes, I can.
Okay, my name is Kamla Sekena. I'm calling from Port Harcourt. Thank you very much, Mr. Blessing, for a good presentation. My question is on meetings, notice of meetings and attendance of meetings. And my question is, can a company secretary alter the articles to include a proviso for shareholders that are yet to comply with their shareholding commitments in relation to notice and attendance of meetings? Because when you were speaking on that, you said there are some certain shareholders that if they haven't fulfilled, I think I'm paraphrasing it, but if they haven't fulfilled their shareholding commitment as to payments of shares, the company may decide not to send them a notice of meeting. So I'm asking if the articles of the company can be altered to include that.
Now, your question, sorry, if I repeat your question, can the articles of the company be altered?
Yes.
To do what?
Include a proviso that if shareholders have not fulfilled their shareholding commitment, they may not have a notice to attend meetings. I don't know how to phrase it.
Your question is very, very clear. Don't worry. Your question is wonderfully
All right,
clear.
thank you.
Okay. Okay.
Somebody's hand is raised.
Speaker, sir. Speaker, you can take these two questions, then we'll take some more questions.
Okay. Thank you very much. So the first of two questions that essentially is asking to know if there are stringent procedures regarding the appointment of company secretary. First of all, the procedure for the appointment of the company secretary is generally stated in CAMA. How to appoint the company secretary, who to appoint is there in CAMA. There are no stringent procedures regarding the appointment of secretaries of a private company. The appointment provision in CAMA was actually specific as to the appointment of secretaries in a public company. Okay, now CAMA has these provisions in CAMA places the obligation on the board to ensure the qualification, competence, and experience of the company secretary to be appointed. So the responsibility or the buck stops with the board in ensuring that whomsoever is appointed bears the competencies, skills, and the qualification necessary to execute the role or duties of the company secretary. However, in relation to public companies, CAMA goes a step further to specifically determine the minimum basic qualification that the company secretary must have. He should either be a legal practitioner called to the Nigerian bar, a chartered secretary, or a member of Icsan or any other accounting body, or work in a firm that renders services either as chartered secretaries, legal practitioners, or Icsan, or in 3 of the last 5 years of his engagement, he had worked as a secretary of a public company. These are the requirements. Now, that is what CAMA provides as the guide. However, taking it a step further, again, for public companies, sectoral regulators have deepened the conversation. Let me see, if you look at the corporate governance guidelines published by CBN recently in 2002, said is that even the appointment of the company secretary must come with the prior approval of the CBN. Not only that, you cannot, without the prior approval of the CBN, appoint a company secretary of a bank, a commercial bank, or any of the banks regulated that are for which the regulation was stipulated. You cannot appoint him and make him company secretary and head legal. Those offices must be separated. So my point is, CAMA lays the standard minimum basic requirement for the appointment of a secretary of a public company. But the sectoral regulators have, in some cases, deepened the conversation to ensure that there is some level of protection, or supervision or control on their part over the mode and manner of appointment and removal of the company secretary. So essentially, that is the answer to the question. Is it more stringent or not? That is a matter of perception. If CBN says the person you are appointing, you must take approval from us. When you are removing him, you must take approval from us. That is CBN's guideline. Usually, CBN will not tell you why they are doing that, but they do that all the same. And the guideline, as you know it, is a subsidiary legislation. So it has the full force of law because it also provides penalties. Failure by the bank to notify the CBN is usually met with steep sanctions, very heavy sanctions as are applicable. So to answer your question straight up, private companies, there are no such regulations, just the expectation that the company secretary should be qualified enough to know what to do. Public companies must meet the minimum basic requirements under CAMA. Companies under sectorial regulation, it goes a step further if the sector regulator is minded to include that provision. Now, to the second question. The second question is simple and straightforward. Can the company, an existing company now, amend its articles to include a provision that the right to vote, attend, vote, and speak at the annual general meeting of the company is subject to the fact that there is no default or demur on the payment of costs or existing payment or outstanding payment on the shares? The answer to your question is yes, it can, but the procedure must be followed. And what is the procedure? You must call an extraordinary general meeting of the company because you are amending the articles. So a special resolution will be required to achieve that. And for that resolution to be passed, 2/3, that is 75% of the votes of the members attending and voting must vote in favor of. In addition to the fact that for the meeting to even convene or commence, it must be quorate. So you can amend. That is a simplistic, straightforward answer, but you must comply because they need to have a say in whether or not, I'm talking of the shareholders now, they need to have a say in whether or not you putting that in the articles is to their advantage. So that is where the democracy of the meeting will now come to bear. Shareholders will vote. If you have weighty shareholders with majority control over the company, surely they can muzzle their way in. They can even insist that before the meeting, they can even give notice that we should determine the votes by poll so that the weight of their votes will make sure their article is amended in their favor, including it. But if we have commoners, I'm sorry, let me use the common Hausa word, the talakawas, people who want to share, and they are in the majority, and they know that many of them are owing. You may have a stumbling block, but that is a procedural thing at the level of the meeting. So your question, is it doable? The answer is it is doable, subject to your complying with the laid down rules under CAMA for the amendment of the articles, and that will require 75% of the votes of all those who make the quorum casting in favor of the amendment. Thank you.
Thank you. Thank you. If you want any more, you may ask your question.
Thank you. Good afternoon. My question is, you mentioned calling the meeting to order. I wanted to know what that means and how do you do that in a meeting, in like an active meeting? How do you call a meeting to order?
All right. All right. It's a very simple thing. Have you ever been when you were in school? Were you in the Interact Club?
Yes.
I'm just trying to I'm trying to bring down a scenario. If you attend family meetings and all that, or community meetings, fancy a situation where somebody uses the bell. I hereby call this meeting to order. Bam! You see that chiming of the bell, or using the gavel, whatever the case is, or making the pronouncement. Calling the meeting to order means, well, let us mentally travel back to the curtilage of the AGM. Members are all seated. They are having conversation. The meeting has not started. The members at the high table, under the guide of the chair, have taken their position. They want to start. Ladies and gentlemen, it is now 10 o'clock. I hereby call this meeting to order. Immediately he says that it means that the business of the AGM wants to start. There are no hard and fast rules. It's a declaration by the chairman that the meeting is hereby called to order, and everybody behaves and puts himself in the position of participating in the meeting. All pre-existing conversations, discussions, all committees that are having their private spree are dissolved, and everybody listens to the chairman. That is what it means to call the meeting to order. Nothing fantastic, just a procedural requirement that signals the commencement of the meeting.
Thank you. Thank you. We'll take the very last question now from Lady Matanaya.
Okay, good evening, sir. Thank you so much.
Please be audible.
Can you hear me now?
Yes, I can.
Okay. So, sir, you were making a statement about single shareholdings and small companies exempted from AGMs. Now, what's the position of CAMA on annual general meetings for company incorporated by trustees? Do they also hold annual general meetings? Because you didn't mention that. That's my question. Thank you.
A company incorporated by trustees are not under Part B of CAMA. We are dealing with companies under, and we don't have companies incorporated by trustees. They're not strictly speaking companies. We have incorporated trustees, not companies incorporated by trustees. If you have a residence association incorporated under that part of CAMA, it is not a company. Are you getting where I'm coming from?
Yes, I can hear you.
It's misnaming it, but let me answer your question. Part B of CAMA is specifically dedicated to limited liability or in companies limited by shares, limited by guarantee, and companies with unlimited liability. That is what Part B is dedicated to. And companies, incorporated trustees don't come near here at all to raise any matter regarding incorporated trustees because they are not under Part B. We are discussing about companies under Part B. There are regulations there. For instance, they don't have shareholders there. Okay, they don't have any relationship with shareholders. They are more like creating trustee as a corporate entity to do the same things that a company limited by guarantee can do under Part B of CAMA. But the difference being that the liability, the corporate personality is in a board called the Board of Trustees. It's not the trustees of the as a collectivity they bear the corporate personality of the association. Here, a company limited by guarantee is separate from its members. I don't know whether you get my point.
Yes, I get you.
So, company limited by guarantee and companies incorporated or provided for under Part B of CAMA have no relationship directly, indirectly, or even tangentially to what is happening on somewhere in Part F or Part. In fact, at the backside of CAMA, no business whatsoever. They are totally distinct and distinguishable entities, and it will help if it does not cause any confusion. The trustees that are incorporated are human beings coming together, and then they are the ones that bear the corporate personality of the association. Are you getting the point? That is why if you are suing a church, they say you are suing the incorporated trustees of. They are the ones that have been held out in trust for the members. So the trustees of bear the corporate legal personality. They are not a company. They are not a company at all. So they will not feature under our conversation in relation to.
Thank you. Thank you. Before we go to the final item, Mr. Eyidengha, we
Yes,
have
sir.
with us one of our past chairmen. That's Mr. Emeka Noha, FCIS, PhD. His question is as follows. How prepared are we for corporate meetings with AI, that as artificial intelligence, as we will soon be confronted with this reality? Did you get that?
Just a minute, sir. How prepared are we for corporate meetings with AI?
Yes, with artificial intelligence.
Well, that's a very interesting and naughty question, and I hope the answer I have will be adequate to answer it, because the issue of artificial intelligence is still a pulsating one. It's still an evolving one. People are still trying to define the parameters and levels of application. Artificial intelligence essentially signals, a separation from human involvement. Okay, so to the extent that meetings are regulated by the Act, to the extent also that the Act has made provision for electronic participation, the role the AI will play in terms of meeting, for me, it will be difficult to conceive. I don't think whether now or in the near future, AI will replace the necessity of members meeting, whether electronically or physically, when it comes to matters affecting general meetings of the company. It will take a lot of technological investment in specific area to allow for audit of the AI, to test its functionality, and proven over time to be useful for what it is designed to achieve before it can be deployed to corporate company practices, particularly or especially in areas of having company meetings. So to my mind, to your question, how prepared are we? I would answer that we are not really prepared. It is most unlikely that our preparation is anything that will take flight in the immediate or near future.
Thank you, Mr. Eyidengha. For time, we may have had to ask to receive some more questions, but the day is fast spent, and actually, thank you everybody for participating. And the questions were I mean, the quantity of questions, in my very humble opinion, suggests most of what the speaker has presented has been properly digested. Now, I would call on Mrs. Wulari to take the vote of thanks, but before she takes the vote of thanks, I would just make two announcements. One would be, please, for those, I saw many questions asked whether the materials for the lecture will be circulated. Yes, they will be circulated. So rest assured, even some of the questions that were not answered will be answered together with the circulated materials. For those that are intending to receive certificates for attending this training, the cost has been published as 2,500 Naira. The lecture itself is free. Certification is 2,500 Naira, and you can check in the chat boxes you would see the number to call and the name to call going forward. Please, Mrs. Mulari, could you give the vote of thanks?
Okay. Thank you, everyone. I would like to start by saying that I'm really very glad I was able to meet up with this lecture. I just came in from Calabar this morning, and as we all know, that road is a very special road. Let me just put it that way. But I'm really very glad I was able to meet up and join with this lecture. I was very, impressed as usual with the quality of work that was put out by my very good friend, Mr. Blessing. So on behalf of the River State chapter of Icsan, I would really like to extend our heartfelt appreciation to everyone who has made today's lecture a success. I would like to thank the EXCO and everybody that helped to organize this public lecture for their meticulous planning and for the dedication in putting together this lecture. As you can see, the hard work has truly paid off. And I would really, really, really like to give a special thank you to Mr. Blessing. Whenever I, have occasion to interact with him, I always come out better and enriched. So thank you so much, Blessing. Your article has been very insightful, has, reminded me of things that I have even forgotten. And I'm sure everybody has been enriched by, listening to you this afternoon. I would really like to say a big thank you to you. And of course, your expertise is deeply appreciated. Thank you so much. So thank you as well to the chairman for putting this together, to the vice chairman. I've already thanked all the EXCO. Thank you so much. And lastly, I would like to thank everybody that attended. Of course, if you were not here, this would not have been possible. So thank you to all the attendees, your presence and your participation, especially just like the vice chairman said, your questions, the questions that you have asked has really proved that, you were engaged and listening. So thank you for that. So thank you for your time. Thank you for your attention. Thank you for your contribution. And just thank you. Thank you once again. And we look forward to having future gatherings where, we will all be enriched and, just make ourselves better. Thank you so much.
Yes, thank you, Larry. And on a closing note, I'll say thank you to everybody. Thank you, Chairman. Thank you, Speaker. Thank you, all attendees. Please take the time to check us out on YouTube and other social media. Also look out for a lot more of these lectures. Some of them will be free like this, some won't be free, but trust that the cost won't be an arm and a leg. On this note, I would bring this entire lecture to a close and wish all of us a wonderful day. Bye for now.
Bye, sir. Thank you.
Bye. Thank you so much.
Thank you so much.
Sir. We're grateful.
Thank you, sir.
Thank you.
Thank you. Appreciate it.
Thank you, Mr. Blessing.
Thank you so much, Mr. Moderator. Thank you, my chair. Thank you so
Thank you so much.
Matanaya, where are you? Good to hear from